Good afternoon, everyone. I'm very happy to be here with you today as well for the third time. Today we have a very specific topic, so please sit back and relax. This will be rather informative to those of you who are not that familiar with the concept of legal clinics and clinical legal education. And as you must know, this spring school is in a way a preparation for the future master program, within which one of the subjects will be also the gender equality legal clinic. So the idea is to inform you about the benefits of clinical legal education as a very valuable, very important interactive teaching tool for law students. But before I present some general purposes of clinical legal education, before I present legal clinics that are already functioning here at the University of Belgrade Faculty of Law, as well as what we intend to do within the gender equality legal clinic once it is established, I would first like to hear about your experiences with clinical legal education. Does anyone know anything about the concept? Has anyone had previous experience, maybe attended some legal clinics? I know that Katarina here has. Actually, she was one of the students that attended the refugee legal clinic last semester, but this is also a question for those who are following us online, especially those that are not from the University of Belgrade Faculty of Law. Please be free to intervene. We would very much like to hear about your experiences. So it appears that, at least regarding those who are present here in the room, only Katarina is the one who has. Oh, Nemanja, you had. Please take the floor.
First semester of this academic year, I was on e-clinic.
E-clinic.
We were having homeworks. Every student had one case, how we would solve it as lawyers, and it was in a pro bono nature.
Yeah, this legal clinic is actually a bit specific because it is not coordinated by any of the teachers from our faculty, but we have a cooperation with one non-governmental organization, pro bono, if I'm not mistaken, and they work with our students. Thank you, Nemanja. So for the others who do not have a previous experience, let me just inform you about some origins of clinical legal education in general in the world. So according to available research, this is a rather old concept. You can see that as early as in the 1900s, this concept of teaching began to be established in the world. And regarding this issue, and for further reading, I would kindly invite you to, if you are interested, of course, to read the article that you have available on the Moodle platform. Professor Vujadinović, our dear colleague from the Örebro University, and myself, we published an article dealing with also gender equality legal clinic, but clinical legal education in general, in an international journal of clinical legal education. So you have it on the Moodle platform. You may read it if you wish. So, as I said, this is a rather old concept, and it first started to evolve within non-profit organizations, so not within universities. But later on, it also was transposed to universities, and law faculties actually started to implement such programs and to use them to enhance the capacities, legal skills of their students. When it comes to our region, Central and Eastern Europe, legal clinics started to be applied and implemented in the 1990s. And also for those who are maybe more interested, there is, and just to give you an idea how widespread this concept is worldwide, but also in Europe, just to know that there is a European network for clinical legal education, so a whole network of different practitioners, activists that are using this method either within universities or, as I said, NGOs. So the idea of this network is to cooperate, to share good practices, to enhance further the benefits of clinical legal education. Now, what are the general purposes of clinical legal education? And when we say legal clinics, the first idea that comes to our mind is working with real life clients. So you have real people who have real legal problems, who come to, for example, the faculty, the legal clinic, which is operating at the faculty, and under the supervision of teachers, of different professionals, practitioners that are engaged in working with our students, real clients have the possibility to receive free legal aid. Unfortunately, for the reasons that I will come to a bit later, this is not something that we can do anymore. But generally, as I said, clinical legal education is most recognized with regard to this purpose. On the other hand, what is the other benefit for the students themselves? Very often we hear comments from students who graduate from law faculties that when they start working, when they start practicing law, they know nothing. That actually the theoretical knowledge, the knowledge that they gained during legal studies was not enough. It was not enough to prepare them for what was expected from them once they start to practice law. So legal clinics, through the methods of teaching that they are using, actually aim to overcome this discrepancy between something that is written in the textbooks and something that law in practice actually is. In that way, we also contribute to enhancing professional ethics among law students. So we are preparing them better, actually legal clinics are preparing them better for their future legal professions. And as you will see later, among other lectures that are delivered within legal clinics, we have the legal ethics course. So this is something that is very important for not only students, their education, but also the legal profession in general. But you can imagine who are those potential clients for legal clinics, at least those legal clinics that can work with real-life clients, but also, as you will see later, according to the topics that specific legal clinics cover, legal clinics usually deal with not anyone, but those who need free legal aid, those who are marginalized, disadvantaged, vulnerable categories of people who cannot receive relevant legal advice through law offices or at other places. But through legal clinics in general, we actually aim to sensitize students for pro bono work, for caring about those who are disadvantaged and vulnerable. Also, one very important aim of legal clinics is advocacy training for law reforms. I will just give you an example, something that we did within anti-trafficking legal clinic in combating human trafficking. So at the time, the national strategy on human trafficking of the Republic of Serbia was supposed to be adopted, as well as the action plan. So what we did within this legal clinic is organize the public debate here at the faculty, and afterwards the students that attended this program, they sent very constructive, very useful comments and proposals to the text of the action plan and national strategy, and they were implemented in the final text of the national strategy and the action plan. So the idea is also to develop those advocacy skills among students that attend legal clinics. And finally, legal clinics tend to enable students to challenge the capacity of the legal system to address changes in societies. And this is something that will be very important also within the gender equality legal clinic that we intend to implement at the master program. Now, based on these different aims, purposes that I outlined, maybe we can classify them into three big groups. So there are certain benefits of legal clinics for the students themselves. Because this is a very important, very interesting, powerful pedagogical model, which enables students to first revise the previous knowledge that they acquire through attending various regular courses at the university, but then to go a step further and to enable students to acquire additional training, but not only training, not only knowledge, but skills as well. So the focus within legal clinics is on developing legal skills and analytical skills, of course, of students. Then there is the other set of aims, of goals, those from which actually the legal profession can benefit, because by training students regarding acquiring legal skills, this will definitely also be very, very important for the legal profession, for future lawyers that our students will become. And finally, something that is also very important, it actually engages universities in the life of the community. How? Through something that I already mentioned, through paying attention to the various problems that specific categories of vulnerable categories, marginalized categories of persons are facing, through sensitizing students to pro bono work, the idea that once they become lawyers, they need to give something back to the society and offer free legal aid to those who are in need, even though they do not have resources to pay for legal services. So how do we do it here at the faculty? We have, as you can see here on the slide, many legal clinics that are currently operating. It all started with the family law legal clinic. I think that was the first one, and I must mention Professor Marija Draškić, who was one of the founders, actually the founder of legal clinics, but Professor Krstić was there from the very beginning, and I also invite her to intervene whenever it is possible, because she's far more experienced and longer in this topic than I am. But as I said, it all started with family law legal clinic, and then legal clinics developed through other areas of law. So we have certain legal clinics that actually specialize in those regular courses, with regard to regular courses that are offered to law students at the bachelor level of legal studies. But then you can see that there are some legal clinics that focus on some specific, very specific topics that are not that dealt with in depth manner throughout the bachelor legal studies. For example, asylum and refugee law, legal clinic. We only tackle certain issues regarding refugee law, asylum law through international human rights course, through public international law course, but these are only scarce. Actually, several classes are dedicated to these topics. So you have here the entire semester covering various topics in this area. Anti-discrimination law legal clinic that Professor Krstić is in charge of, and as you will see later, among all of these that are operating at the moment, most relevant for the issue that is of interest for us, so the issue of gender equality. Anti-corruption law legal clinic, we have environmental law legal clinic on combating human trafficking that I already mentioned, and the newest member of our legal clinics family, the administrative law legal clinic, which has started in February. This was the first semester that this program was offered to our students. So how do we achieve these goals that I mentioned through these different legal clinics? Well, again, the methods that we use, the techniques that we use can be classified into three large categories. First of all, lectures, but not classical lectures that students are used to within regular courses at bachelor studies, because these lectures are first topic specific. As you can see, and as I mentioned, first thing that we teach students is legal ethics. Then skills of communication with clients, so how to speak with clients, how to interview them, how to communicate with them. And of course, later on, we focus on providing in-depth, very specific, specialized knowledge in the specific area of law that the legal clinic in question deals with. But these lectures are not, or mostly are not, delivered by our professors here from the faculty, but those who are practitioners. So we invite, for example, judges, prosecutors, lawyers, professionals from other state bodies that are of relevance for the specific topic, or even experts from international organizations, non-governmental organizations that are active in the field. On the other hand, what is even more important is a wide range of different interactive teaching methods that are used. So just to give you an idea, legal case studies. So the focus is on either real cases or hypothetical cases that students are solving within the specific legal clinics. They are educated, trained how to write various legal acts, legal opinions, legal analysis. We do simulations, for example, those legal clinics that refer to classic courses, for example, family law, criminal law. Simulations are organized throughout those courses, and simulations are organized and held, again, not necessarily with our professors, with our colleagues, but judges that are cooperating with the faculty within this specific legal clinic. Moot courts are also an option. But we go also outside the faculty, so our students have an opportunity to work, to gain different practices, experiences with our external partners, meaning, as I said, different state actors, state bodies, non-governmental organizations, but also international organizations, either through different kinds of practical work, study visits, field visits, trainings, etc., etc. Now, anything that I didn't mention and you would maybe suppose that it should be the case here, it should be stated here. Something that I said that we cannot unfortunately do here at the faculty, and this is work with real life clients. So unfortunately, ever since the new law on free legal aid and legal support of the Republic of Serbia started to be applied, we cannot use this interactive method, so we cannot have real life clients here at the faculty, and we are deprived, and our students are deprived of this very, very important pedagogical method. Why is this the case? Because the law, unfortunately, does not recognize law faculties and legal clinics as providers of free legal aid. So the only thing that, according to the law, law faculties can do is offer free legal support, which, as defined by the law, actually relates to filling out different forms. So you can imagine that this kind of activity within legal clinics is not very important, challenging, interesting for useful for our students. Neither of the universities in Serbia that offer clinical legal education decided to register with the Ministry of Justice in accordance with this law in order to be able to provide free legal support. So this is actually a very important limiting, restricting factor, and we cannot, as I said, do with real-life clients, unfortunately. So this is something that is a real challenge in running legal clinics in Serbia in general. But when it comes to gender equality in particular, what can be considered as a challenge in that regard is definitely, and I'm sure that you got an idea so far because the spring school has been you've been attending the lectures within the spring school for a couple of days now, 5 days now, and you have the idea that unfortunately there is insufficient commitment to issues of gender sensitive practice in general education of law students. And on the other hand, what we always stressed is this very complex aspect of gender issues, meaning that this is a very difficult, complex, both legal and social phenomena. The issue of intersectionality that we mentioned, the fact that gender issues are recognized throughout different fields of law. So this is generally a very a big challenge for introducing certain gender equality issues within the existing legal clinics, and that is why a specific clinic dealing with gender equality would be a good step, an excellent step forward. As I said, this does not mean that we do not deal with different gender issues within the existing legal clinics, not only at the Faculty of Law University of Belgrade, but at other universities in Serbia. And just to give you an idea, you have here on the slide the information that there is a women's rights legal clinic operating at the Faculty of Law University of Niš. So it is fully dedicated to women's rights, both at the level of international instruments and national law. Students within this legal clinic deal with, of course, discrimination and gender-based inequality. The issue of domestic violence is also one of the topics dealt with within this legal clinic, but generally protecting women's personal integrity, also property rights, so different aspects of women's rights. In Novi Sad and Kragujevac, there are legal clinics that specialize in domestic violence, an aspect which is also very relevant for the topic. So they focus on women as victims of domestic violence, but also women as victims of gender-based violence. And finally, something that we are very proud of, the Anti-Discrimination Law Legal Clinic that is operating for how long?
Since 2011.
Since 2011. And of course, within this legal clinic, every year different issues relating to gender equality are dealt with. But if I'm not mistaken, 1 year you had a specific optional module that only focused on gender-based discrimination. So the practice of the CEDAW committee was focused throughout this optional module. So this legal clinic is not maybe, but for surely most specialized for the issues of gender equality and gender-based discrimination. On the other hand, some other clinics that do not specialize in gender equality, but that deal with certain aspects of relevance for gender equality. Just to give you an idea, Family Law Legal Clinic, which is operating here at our faculty and at the University of Union. It covers certain sessions actually concern issues involving implementation of the law on prevention of domestic violence. They deal with educating students to properly understand the cases of gender-based violence, etc., etc. I mentioned earlier the Refugee Law Legal Clinic. Every year, one session is dedicated to gender aspects of international refugee law. This year, for example, within this legal clinic, we organized a students' conference. So we separated students in several groups, and each group had a topic to deal with, research, and then to write a paper together. One of the topics, and that was the group mentored by Professor Krstić, their topic was gender aspects of international refugee law. The last one, Legal Clinic on Combating Human Trafficking, we regularly, thanks to cooperation with different NGOs, and in this regard I must stress that Athena was our main partner regarding gender issues. We regularly organize workshops for students during COVID when the entire when the teaching was exclusively online. We organized a webinar for students on new responses to trafficking and violence against women and girls in the context of global migration. And last year, and this is this WOW at the end of the slide, you might be wondering what this is, but this is Women on the Way. It is an advocacy group consisting of women who are currently either asylum seekers or already refugees in the Republic of Serbia, and who came here at the faculty last year. We organized this event together with Professor Vujadinović and her students from Gender Studies. So the idea was to have them here, so women who are actually asylum seekers, refugees, and also potential victims of human trafficking on the migratory route that they had to cross. So our students had a chance to listen to them, to their experiences, problems that they faced along the way from their countries of origin on the route towards Serbia, where they sought international protection and refuge. If I'm not mistaken, the video is available on the Long Life Learning platform. So for those who are interested, you can take a look at this event and the very moving, to say the least, testimonies of those three girls who were our guests last May here at the faculty. So now that you have an overview of the general purposes of legal clinics and what has been done so far within different legal clinics that operate here at the faculty, the question is, why is it important to have special legal clinic dedicated to gender equality? Well, again, for all the reasons that we discussed during the last couple of days. First of all, because women face various gender-related obstacles in accessing justice. Governmental schemes for legal aid are simply not sufficient to support women, or at least certain categories of women. Then there are reasons that relate to different forms of ill treatment towards women before the law and in court proceedings, for example, gender insensitive laws, gender bias in courts, gender incompetent interpretation of law, judgments made in a gender incompetent manner, and finally, the wide variety of legal problems concerning women's rights, the fact that they are recognized within a wide variety, again, of different legal fields. This suggests that an all-encompassing, comprehensive approach to dealing with these topics is needed, and that a specialized legal clinic should be established. So what will be the objects of the future gender equality legal clinic? First of all, to increase gender consciousness of law students, but also knowledge of intersectional perspective in handling cases. Then it is always about critical thinking and critical analysis. So the purpose, the aim of the Gender Equality Legal Clinic will be to enhance students' ability to critically analyze structural inequalities and propose constructive changes to the legal and justice system, but also to develop students' capacities to work with different stakeholders, state bodies, national organizations, non-governmental organizations, international bodies, international organizations, and to further cooperate with civil society, because regarding this topic in particular, the cooperation of the faculty with different NGOs that are active in the field is very important in order to train students to advocate for gender justice. And when it comes to outcomes, so what we intend, which skills, which capabilities we intend to develop among students who attend Gender Equality Legal Clinic. First of all, of course, knowledge, but in that profound, very specific knowledge on the importance of gender and intersectional gender analysis through looking at rules, policies, practices, but not only within the national legal system, but also international and at the regional level as well. So the focus will be on comprehensive knowledge in this area. Of course, the focus is on skills. So what skills are needed to provide advice, including legal services to victims of certain crimes, with special attention to social positionality of the victims in relation to gender, sexuality, race, class, ethnicity, disability, etc. And finally, the students should have the ability to cooperate with other organizations, to advocate for achieving gender justice, etc., etc. So these are the aims that we, and goals and outcomes that we would like to achieve through the future Gender Equality Legal Clinic. So what will be its added value? First of all, it will not focus on only one single gender issue, but it will cover a wide range of issues. And something that we mentioned regularly during previous lectures, intersectionality, so this intersectional perspective and across different fields of law, the focus will be on that, of course, with innovative methodological approach. And there we come to the problem, through which method, because we cannot, as you now know, work with real-life clients, so we have to think of other methods to achieve those goals. So these are some ideas. We will, of course, develop them even further and think of other methods that we will be using during the Gender Equality Legal Clinic program. If you have certain suggestions or proposals, judging on your previous experience from the perspective of students, please approach us. We are open to any suggestions. But something that we intend to do is, for example, that our students start drafting different summaries and fact sheets of international standards on various gender issues. you must be aware of the fact that unfortunately our judges are not that familiar with international standards, not just in this area, but generally. So preparing relevant briefs, relevant summaries of the case law of different international bodies, CEDAW, European Court of Human Rights, other bodies that we mentioned during the last couple of days, that will be very, very beneficial, not only for students, but also for other practitioners. So why not offer relevant interested stakeholders the results of the work of our students? We intend that our students conduct analysis of existing national legislative and judicial practices. In what way? To see to what extent they are in line with the international standards that are there. We have an ambitious idea that our students will draft reports to be submitted to relevant international bodies through different procedures that we also talked about during the previous classes. So why not offer some specific information, knowledge on the practices in Serbia and give them to send them to relevant international bodies. Preparing briefs, legal analysis and opinions for different stakeholders. We intend to, for example, organize debates on specific issues relating to gender equality, maybe to offer special debates regarding certain categories of women. So maybe one debate dealing with women refugees, or Roma women, or women with disabilities, and then invite professionals, experts in that particular matter to discuss certain open issues, problematic issues in legal practice with our students. And finally, something that we may also do within Gender Equality Legal Clinic, and this is provide Know Your Rights info sessions. So to inform interested persons about the rights, about the relevant procedures that they have at their disposal. Since we are not allowed to offer free legal advice, this will be the only substitute for the limit that unfortunately we now have with the law on free legal aid. So these are some ideas that we have. But as I said, and with this I conclude, we are open to any suggestions coming from you, coming from the student perspective. So what you think would also be beneficial, what you think would be interesting, which methods to use during this program. And now that you have an idea about clinical legal education, and since only 2 of you were involved at some of the legal clinics, my question is, would you like to be a part of clinical legal education? Does it sound useful? Does it sound interesting? What are your comments?
GELC
especially Gender Equality Legal Clinic, but we still do not have it. Once that we establish it, yeah, definitely. But this will be for master students. Nemanja.
Would there be visits, so meeting people who are connected with the gender issues, like, ne znam kako se kaže povjerenica. Commissioner.
Definitely. Our faculty has a long-standing cooperation with the Office of the Commissioner for the Protection of Equality. So yes, that would be the most important institution. The idea is, but this is something that is already being done, sending our students to receive relevant training within different institutions and organizations that deal with specific issues. Yeah, definitely. Any other comments or questions? Tijana Stanojević raised a hand. Tijana, please, the floor is yours.
I would say I was a part anti-corruption clinic in 2013, and for me it was a very great experience. And it gives, I would like to encourage the colleagues to apply for the clinics because it gives so value information, and it gives other way of learning things, especially in law.
Thank you, Tijana. Thank you for such nice comments. They go to Professor Krstić, who is also in charge of that legal clinic. And thank you for encouraging the other students that are here. I'm looking at Natasha and Sofia. They are at the third year of their studies. Next year they have to choose either nomotechnics or legal, one of the legal clinics. So I expect to see you next week within one of the legal clinics. Farnaz, please.
Actually, because I'm Iranian, and especially in 2018, if you remember, there was a huge number of Iranian asylum seekers here, and also Afghans. And since I know Turkish, I remember also we had some Kurdish people from Turkey who were asylum seekers. Me personally, I was in contact with them a lot. I tried a lot to work even as a volunteer in asylum protection, I don't know, a refugee center. I applied a lot, but I haven't found any chance to work or participate in any activity so far. If there is any chance, for sure, I would appreciate it.
Thank you, Farnaz. As I said, unfortunately, for example, with this refugee law legal clinic, we cannot work directly with asylum seekers. We are not allowed, but our students do have relevant training on different aspects. And we organize, depending on the capacities of our partners, the UNHCR and different non-governmental organizations, also some kinds of field visits. For example, we regularly visit the Center for Asylum Seekers, one of the centers. This year we went to Krnjača, Katarina. Yeah, Katarina was there. Several years ago, we visited Banja Koviljača Center for Asylum Seekers. So yeah, Farnaz, you're welcome to join if you are interested in this topic. That legal clinic is organized in the autumn semester. So it starts in October. I think that we have something in the chat, if I'm not mistaken. Ksenia says, legal clinics are a very useful thing for becoming a professional. It would also be a very useful and interesting to exchange knowledge and experience between legal clinics of different countries, forming cooperation as well. Ksenia, excellent point, something that we also had in mind, because you know that this gender equality legal clinic has emerged from the Law Jam project that we have with several well-known, very respective faculties, European faculties. So the idea is actually to cooperate with them, because they have different means at their disposal. We can learn a lot from them. Maybe they can learn something from us. I hope so. So yeah, this will be an opportunity to exchange good practices with our partners, because we were all in the same project dedicated to gender aspects of law. Any more comments? Angelia, please.
I would also like to encourage my younger colleagues to go to the clinics, because when you spoke, Professor, I remembered I was in a civil clinic, and that was the first time I actually saw some legal acts. We met a lot of advocates, a lot of judges, and also we had a guest from Faculty of Philosophy, from psychology, and it was very useful for me, because it was in the first semester of fourth year, and in the second semester we had our public process civil process law, and it was very helpful to me to study for the exam because we worked so much at that clinic. So I would like to encourage my younger colleagues to do so, especially on they have various clinics today to choose.
Yeah, thank you, Angelia. I'm glad that you are satisfied with this program. As I said, each legal clinic has its own coordinator, and the way it functions is, of course, depends on how it is coordinated. So there are different methods used. For example, the civil law legal clinic can of course use some other methods, different methods than what we do within, for example, refugee legal clinic or human trafficking legal clinic. But yeah, the diversity is, I think, a good side of our clinical legal education here at the faculty, and we are very happy that very soon, I suppose, we will have another one. The 11th, I think, that Gender Equality Legal Clinic will be the 11th member of the legal clinics family here at the University of Belgrade Faculty of Law. Okay, so with this, I would conclude. Thank you for your attention, and give the floor to my dear colleague, Professor Krstić.
Good afternoon from my side as well. You haven't seen me for a long time, but I'm really happy to be here today. And first of all, congratulations to Professor Čučković for an excellent presentation, and not only for excellent presentation, but for our work done in the field of legal clinics, and she is the head of our legal clinics. And what you learned, we have so many legal clinics, and it's really hard to coordinate this work, but also she's running 2 legal clinics, one on asylum and refugee law and another one on combating human trafficking. And those 2 legal clinics are really very successful program that the law faculty offers to our students. Before I try to find my presentation, I would just like to maybe add that one of the methods that we used for this legal clinic on anti-corruption, and we also have a special module on whistleblowers protection, which was very successful. This year we have a second generation of students going to that program. It's interesting that at some point, and especially when, but even before the law was adopted and restricting the some kind of method that really is so important for legal clinics, and this is work with real clients, as Professor Čučković already explained. What we did, we decided to go outside, to do something to exercise what we call street law. To go outside, and what we published leaflets and with some information on what is corruption, what are the mechanisms to combating corruption, where you can go in a case of corruption. And what we did, we went outside and we spoke to people on the streets. So we went to the main street in Belgrade, to Knez Mihailova Street, and people were shocked that students are there, but they distributed those leaflets, giving very useful information to them. So that can be also another way of how we can approach people, speak with them, and try to find some, first of all, inform them, but also find some useful information for us in order to improve working methods. And I also have to share one experience. As we said, this is really a great program, and still it's not enough to have only legal clinics, and especially in this area, very specific area. And I always return to the use of, the influence of stereotypes that we will also cover in this second part of our session today. And why I'm telling you this? Because for this anti-discrimination legal clinic, 3 years ago, so when Corona just started, we had online lessons, online classes, and the program was dedicated to each vulnerable group for each class. So that was not the case when we had a specialized program on gender equality. And we dealt with different groups. We really insisted on, again, stereotypes and prejudices, on different forms of discrimination. And I really thought that because we had a great and open discussion, that my students in that group, which is a special group of usually 20 students, is open-minded. And then one colleague who is dealing with, who has an organization, running organization dealing with refugees, he said, let's test your students, because what they did before that, they did a polls with student population, but not primarily with students from the law faculty, so from the University of Belgrade. And they really wanted to ask them certain questions on what they see as a reason for refugees to come to Serbia. Do they have any connection with refugee community? Then the question was what they think about people's patrols. So I'm pretty sure that people from Serbia know that those are citizens who take weapons and go outside and play the role of policemen. So I said that would be great to see because the results were really terrifying. And I said, let's compare what our program, which lasted for one semester, can do in order to have to increase the awareness among students. And what do you think? What was the result? How data were different, the results of this survey that we did with students, with a specialized group of students, compared to the, let's say, general population of students? Can you guess? Any guess? Mina, what do you think?
Well, sorry, I'm not sure. Probably, like, in the context that you have mentioned it was not so different from the general population. Certainly their attitudes have changed over time, but like in general, maybe there wasn't such a gap between the general population. And am I wrong?
No, you're actually right. I was so shocked when I've seen that the results were so similar. And then I took the glass of wine and I said, oh, we really need to do more. So why I'm telling you this, it's a long-lasting process. You cannot expect that you will change the perception of people so easily. So this is when we return to the issue of judges, why we need this continuous training. So not all, or to offer one training, 1 day training, 2 day trainings, and to think that we are making a progress. No, it's a really long-lasting process where media and some other actors with shaping public narrative can really very much influence what we think and what we believe is right or wrong. And basically, Serbia is not the only country which suffers from this. It's a common problem everywhere, so it's a global problem. And this is why we have this feminist judgments projects which started all over the world. We still do not have that the whole world is covered by these projects, but what is interesting is that scholars, especially from common law countries, they initiated very spontaneously this project. So what this is about, we criticize judges, but in order to allow them to understand where the critique goes, because usually academic debate is a very theoretical debate, and judges, they will not make an effort to understand basically what's wrong about their judgments. So the only way to show how they're wrong is to rewrite the judgment. So what does it mean? It means to offer to judges how you will write that judgment in a case that you are the judge. And of course, the deposition is never the same, because judge has another perception of what are the values that should be protected. Academics, they are more open also to some new ways, to some new theories which are coming. But here really the idea is to show how this feminist perspective, how this feminist approach to the usual way of delivering judgments, and this is what we discussed yesterday, that issue of neutrality or objectivity, where dominantly judges believe that they should not take any approach into account, but that they only have facts before them, and that they should just interpret those facts and put them in a context of a legal norm that they need to apply. So how it is different when you take into account this approach. So basically, importance of this project is really to offer to judges how they can differently approach cases in some specific areas. So it's maybe not necessary in all areas to have that approach, but what you will see, we have more and more legal areas in which it is visible that this feminist approach is important. And even in some areas such as tax law, when we do not see maybe directly the relevance with the feminist approach, but then when we apply it, we see how it can result in differently. So basically, here you have one map with, I would just mark all stars, where we have some some project has been initiated. So what you can see here is that, as I said, a common law scholars are leading this process. And what are the roots? So when it started with the US, where a group of scholars, they wanted to rewrite two famous judgments. I'm not sure if you're familiar with these two judgments of the Supreme Court of America. These are Brown versus Board of Education. This is the case that deals with racial discrimination and with affirmative actions in the area of education. And Roe versus Wade, I'm pretty sure that last year you heard about this leading for more than 40 years leading judgment in the area of abortion in the US. So they tried also in these two cases to include a feminist approach and to show to judges how it would be different than this approach was taken into account. Then we have, and you will have this presentation, so you have exactly the titles of publications which were published, and as you can see, inspiration after the US came from Canada, who also wrote and rewrote major judgments of their Supreme Court. Then it was not a surprise that the next step was Great Britain with their title of their monograph, which is called Feminist Judgments from Theory to Practice, when there are 23 judgments of highest courts which were written and where this approach has been taken. Australia is also interesting as they follow what their colleagues in Canada and Great Britain are doing, but then we also have some specific aspects. For example, in Australia, because you know that there we also have some people who are not only minorities, but who are traditionally living in Australia, such as Aborigines, such as Maoris, who also has another perspective, and that perspective was also included. So we see intersectionality, which was included for the first time, where also other elements were taken into account to make a selection of cases, because it's always hard to find, first of all, cases, and then to select which one you will rewrite. After Australia, then again, because I mentioned that in the US we had only two judgments which were written, then scholars from the US decided in 2016 to also pick some other judgments of the Supreme Court and to rewrite them. So we have another book which is called Feminist Judgments: Rewritten Opinions of the United States Supreme Court. And finally, colleagues from Northern Ireland and Irish Feminist Judgments Project was initiated. Together with Australian project, New Zealand was emerged. And here again we have, as in Australia, that approach that also people of certain descent are taken into account. So I here put only for you to see, because it's really hard for you to follow on that map that I showed you where these projects were initiated. But the next step was Africa. and also India. So they also have many cases which are rewritten. And finally, we have two last projects which still do not have books. They do not have monographs, but they are in a final stage of discussion on which cases will be selected. One concerns also Serbia, because this is the Eastern European project, which was initiated a year and a half ago, and also the latest one is a Brazilian project. But like 3 weeks ago, the scholars from these two projects, they had a common workshop, and it was interesting because they shared their experience with cases and the selection of cases. And what was visible is that basically, although we live geographically in totally different parts of the world, that all scholars and from Eastern Europe and also from Brazil identify the same problems, and that the selection of cases goes in the same area of law. So to conclude, these all projects, they focus on national legislation, national cases, pardon me. But we also have one book which is interesting for those who deals with international law. We have this feminist judgments in international law book. And what is interesting here is that basically scholars who decided to rewrite judgments are not rewriting national judgments, but they rewrite judgments of the ICJ, also of the European Court of Human Rights and Court of Justice of the EU, together with international criminal courts, which also means that that the progress has been made. And you've seen it yesterday when we discussed some cases, very good cases of the CEDAW and also of the European Court of Human Rights. But these scholars also identified cases in which that feminist approach was not taken into account. So it's a very interesting book, and I urge you to read it, because it will give you really a very good overview of what feminist projects are about. So why it is important to have these projects, not only because we are really offering the solution. So we are not only criticizing, we are saying to judges, okay, you should think in this way. You should take this kind of approach and come to this kind of result. But also the benefit of these projects is what I already said, that we have more, that usually when we speak about gender equality, we speak about criminal law, we speak about family law, and it's visible that feminist approach needs to be merged there. But we also have, and of course, constitutional law, but for example, housing, the issue of evidence, tax law, administrative law, all these areas are also very important, and with the acknowledgement of that, since 2017, we also have scholars who, and this is a third wave of these feminist projects, who wrote monographs and who rewrote judgments in specific areas. So there we have judgments from different national jurisdictions, but for example, the monograph dealt with tax law, with family law, with reproductive justice, employment, discrimination, and tort opinions. So these are those that we still have, but we can expect more in years to come. So what are the outcomes of these projects? And it's really important to underline that. So these are two possible results that the scholars can show by rewriting judgments. The first one is that if we take into account the feminist approach, it does not necessarily mean that the judge, by delivering the judgment, come to the wrong conclusion. So we can come to that the result of the case will be the same. So the judge will issue the same sentence. The judge will have the same finding. But it is also important what elements are taken into account by coming to that result. And unfortunately, in majority of other cases, not only that approach was not taken into account, but the result will be totally different that approach was taken. So in these cases, it is obvious that, for example, the penalty will be different, that someone will not be immune from the crime that was committed, and so on and so forth. So results are very unjust, and this is clearly shown by rewriting those judgments. So why it is important to have a gender-sensitive judging? I'm pretty sure that all of you are aware after our session yesterday how by applying different approach, it would be important for victims of discrimination to first of all be brave and to urge them, to show them that we have effective legal mechanisms, because we don't have effective legal mechanisms if the result of the case is not just. And this is what we said yesterday. So what would be the result of that? To refrain from using legal mechanisms, and in that sense, it means that we cannot make equality between those available legal remedies and their effectiveness. So you've seen yesterday, the first of all, of how we are giving evidence is something that the judges really need to pay particular attention. And it really depends on the legal system, on how evidence are gathered. But gathering of evidence is a first and crucial step. Because usually judges say, but these are the facts of the case and we need to find a solution under this fact of the case. But if the fact finding was not adequate, if we do not have information under which we can rely on judgment, then we can say that the first step was unsuccessful, and then the result will be definitely wrong. Then also the issue, and which is very connected with this, is admission or exclusion of evidence. Because in that sense also you have a lot of cases in which public prosecutors, they didn't take into account some evidence because they relied on some other rules which are also very restrictive, and which does not also allow prosecutor to collect evidence, to admit those evidence, and then they are used in the court. Assessment of credibility. You've seen yesterday that it is a really crucial challenge in this area, because we have victims who, and if we know the psychology and what they went through, then it is understandable that they will maybe not from the start explain what happened to them. Sometimes they're afraid. If they are victims of human trafficking, they're afraid to reveal who is involved in that. You've seen that refugee case that we mentioned yesterday. In a case of refugee law, if we, for example, do not adjust the asylum system, if it's not gender sensitive, which also means that if you have a woman who travels together with some male, whatever it is, a partner, a relative, whoever it is, and if she has an interview together with him in front of the asylum officer, and she went through some kind of gender-based violence, she will never reveal what happened to her. And at the same time, for example, if she's questioned by a male officer, she will not reveal it. So this is why we really need to understand how to not only gather evidence, but what are the atmosphere in which we are requesting information, because then we will maybe have a problem of credibility. That for the first time, she will say that she travels with her, male partner, and that the acts of persecution are totally different than what in reality happened. And in majority of cases, for example, if we concretely speak about the asylum area, officers will say, "Oh, she is not credible. Her testifying is not credible." So it's very important to know that. And of course, you remember that yesterday we spoke about ideal victims, what we expect. And if we get any information which does not go with that notion, we will again not be sure or certain that credibility of that witness is high. And of course, another very important issue is acknowledging and engaging from gender perspective, which also includes all these processes, as well as seeking further information. Even if you're not getting, we need to know where to search certain evidences. What is a challenge on the part of the courts? And I hope that you see all. So where are the challenges? Courts, we said, are very close and very conservative in a way. They're not so much open to some new ways. And this question for me are really of crucial importance of how judges will proceed. So what we really need, and what is the discussion on the part of the judges in majority of this jurisdiction that I just mentioned. We will see in a Serbian context when this first monograph appears how they will react to this offer of how they should approach to certain cases. First of all is issue of assimilation and anti-subordination. Can anyone guess what this first debate is about? Any guess? This is about the role of the law, what we are achieving by applying the law. And the one issue is the issue to end subordination, which clearly exists, and to achieve substantive equality that we discussed yesterday, or to apply formal equality. If we apply formal equality, then what we are doing? We are not changing the law, we are not interpreting a law from this perspective, which also leads us to the continuation of anti-subordination in a society. Then another challenge is sameness or difference. What does it mean? It again has a very important interpretation of two types of equality, formal and substantive. So what does it mean, sameness or difference? How we are treating men and women, the same or different? What do you think? What do you think? Which approach should be taken into account? Sameness or difference? Are they same or are they different? Different, Natasha? I'm reading. Mina.
In terms of what is crucial is that equality is guaranteed despite the differences, and the problem is when we try to say that sameness is the same as equality. So equality needs to take into account the differences but still guarantee equal treatment in terms of substantive quality.
Yeah, you're right, Mina. So in many debates, basically we need to acknowledge that they are the same, but that there are also some specific, let's say, characteristics of women, like reproductive rights. And in the area of reproductive rights, we need to acknowledge that. But it does not mean that they're treated differently. So it's a huge debate in some countries. Then what do you think? What it is, a backward-looking or forward-looking? Nemanja?
Can men get pregnant?
Can the men get pregnant? I'm referring that question to you. Please answer to me.
Well, something they don't, something they do.
Okay, but how it is relevant for the topic that we are discussing here? I don't get it.
Because there in America there are some currents, meaning some trans people are discriminated when in terms of reproductive rights. So in that sense, we should use. We should include them also in that area.
Okay, now you're more specified what you think about. I agree with you. There are the different discussions and different new waves, let's say. But what I hear share with you is what are the discussions within the judges in some jurisdictions about some cases which already appeared. So, what is backward-looking or forward-looking? What do you think? What this one refers to? What's the discussion here about? Mina?
Not sure. It's just a guess. So maybe in terms of how certain things were looked at and judged in the past, and like what's the pattern of looking at something, what are the changes we can introduce and new perspectives in this regard?
Very good. It means, Nemanja, please.
Is it maybe historical overview?
It means of what the remedies should be about. So is it only an individual approach that we only remedy, for example, compensate someone who was discriminated, or we apply also a broader approach, trying to also issue in some cases that we need affirmative action measures, which will remedy the past discrimination, which is also still deeply rooted in some societies. Yeah, it's very good. It's a the issue of questions. So what the court should issue, what the court should deliver, and whether it's a very limited role or it's a role which is much broader and makes more changes in societies. What is about blindness or consciousness? Nemanja?
Well, that one is easy. If we are able to recognize and to name when we see or have instincts that in some cases we can find discrimination, and right there we will use gender lenses.
Good. So it means, please, Larissa.
Well, I think it refers to blindness and consciousness of biases in the process, in judgments, in the attorney process, everything, in all parts.
You're both right, and we have a huge discussion in some countries where judges say, but you put a lot of pressure on us. You need to have better laws. And if the law is neutral, how we can approach this? You need to give us more in the legislation, because usually judges are overloaded with work. They will not pay, they think that it's a burden on them to pay so much attention to this perspective, and that legislation needs to help them in order to apply better this principle. Very well. What is about individuals or groups? Any guess?
Maybe if that judgments will affect only that individual or the group that individual pertains to.
Very well. So what we are addressing, individuals or disadvantaged group. Nemanja?
In language of Gustav Radbruch, there are situations where two values collide, individual and collectivistic values. So judges must carefully choose which one should prevail, being a bit more important.
Good. It also goes with what Larissa already explained. And we have Ivana Nikolic, who she said groups are very important for indirect discrimination. Yes, this is what we discussed, and we will also discuss it today. So the effect on a group is something very important, especially if you have statistical evidence to show how one neutral provision can, in practice, be discriminatory. What is about intent or effect? What I refer here to? Intent or effect? Any, Larissa?
Well, I also think that it refers to the judgment. So what was the intention of the judge when she conducting this judgment, and what will be the effect that he or she is not aware of?
It's good, because usually we are trying to find intent in discrimination cases, and many judges will judge that it was not discrimination because the intent was not present or was not found. But what we learned from the very beginning of this course is that we don't need to find intent. So here the law should be more focused on effect. What is the effect of certain provision or certain practice? Very well. Private or public? What this discussion is about? Any guess? Nemanja?
In what sense a person can be discriminated, meaning everyone has also private rights and public rights. So which legal way shall we put the case? Private or public?
It's a very good debate, because for a long time what was happening behind the door in private was outside of law. It was not regulated, and it was very hard to be proved. So this is a discussion of the whether also, for example, domestic violence should be treated as an obligation on the part of the state to provide to every person, to protect every person from violent acts. And of course, that this debate was much more vivid before, and now we know that private also is included as well as public space. What about process or substance? And I guess to this, what is this about? Some other thoughts? Sreten?
Maybe in the formal and substantial equality, whether it will be just formally recognized or there will be any material substance around it.
Good. Nemanja, do you want to support this view?
Meaning when we have a trial, judges may severely violate some procedural norms, and in that sense, victims are also protected.
Very well. So this is what we learned yesterday from this Italian case, which was decided by the European Court of Human Rights. You remember that if a witness is exposed to secondary victimization, and if it's a hostile atmosphere, then the whole process will affect the substance and what really happened. So both are equally important. What about singular or multiple identity? What this one is about? Mina?
Well, for me, like the first thing that comes to my mind is the issue of intersectionality, which is, of course, not only the issue of identities, but focuses on the fact that one person can have multiple identities at one time. Also, that identities can be fluid in this time and space. So taking into account the comprehensive picture, not just focusing on one identity as a potential ground for discrimination, and changing the whole approach in this regard.
Very well. So you merged the 9 and 10. Nemanja, please go ahead.
To colleague, just to clarify, does it mean more grounds of discrimination or and also excess of discriminations? If I understood well.
I'm just not sure about the access, but like the whole idea of intersectionality that Professor Dragica has also talked about, and of course Professor Krstić and Čučković during these days, is the fact that in some cases we cannot look at discrimination just for lens of one personal ground, like race, class, yeah. But intersection, actually, not just more, not a simple adding one ground to another, like someone who is a woman and is a Roma woman or is an African American woman, but the intersection of different grounds, which actually change the whole situation in which the person finds himself or herself. And so in this regard, it is of course very challenging to apply this approach in practice, which is something we always deal with when speaking about intersectionality, but just having in mind that the person can be put to an unjust situation and discriminated based on intersection of various grounds in just one case. Sorry for taking the time.
Come on, it was great explanation, and this is the challenge to many courts. It's a challenge how to apply multiple discrimination in each case. What would be the result of that if we acknowledge that we have different grounds for discrimination in one case? And you remember yesterday this case from Portugal that was decided by the European Court of Human Rights, where the court took into account that the applicant was discriminated based on age and sex. So two grounds were important. So one without another will not lead to the same conclusion. And it's important, but many courts are struggling to apply this approach. And then we come to this last one, fixed or fluid identities, which was already mentioned by Mina. So it really means how courts approach the issue of identities, whether it is given by birth or it's fluid, changeable, and in what way it is changeable, and in looking how courts can really differently take this element into account. It is interesting, for example, that in 2021, I'm not sure if you know for that in Bulgaria, the Constitutional Court said that the only term which is enshrined in a constitution is sex. that they do not allow gender as a term and as a concept, and that basically ratification of Istanbul Convention is unconstitutional. We also had in Hungary, for example, in 2020, another interesting approach, which the amendments to the constitution, were initiated, and this is very interesting. Regarding, I'm quoting, regarding children to be raised with a Christian interpretation of gender roles. So this amendment was initiated to protect children's right to be gender identity they were born with. So here again we see their interpretation of that identity. So this is the only sex with which the boy or girl was born with. And we also have some other. Nemanja, please go ahead.
When we talk about fluidity of gender, so just to clarify, do we talk one direction fluidity or multiple directions? Because Republicans have that argument that gender fluidity can be misused, meaning genders can be changed from day to day, from hour to hour, and in that case it could be against legal
certainty.
Security.
Mm-hmm. We speak about different, let's say, discussions which are ongoing. So not about only one, but we have really different discussions in different jurisdictions. From these examples where this concept is really fixed, through some other jurisdictions which are more open to this fluid identity, but then again we have different methods. But you see how many issues we need to resolve in order to find one unique approach to this issue. And it does not mean, it's not necessarily that all of these issues need to be resolved at once. But it also shows how this whole issue is complex and why it is important to have these projects in order to really offer to judges some perspective, to give them a guidance on how they should approach and how they should apply this perspective. So this is all about this presentation. Now we have let's say half an hour for the third part of our session, and you have on your Moodle platform, so please go there and find, maybe some of you already had opportunity to read the case that Professor Čučković and I prepared for a discussion today. So please go read it. You have some 10 minutes. You can also consult for those who are online. You can also put comments in the chat. For you who are here, you can work in pairs if you want and discuss it among you, and then we will discuss it together. But before that, we also have comment from Ivana. She said people can be discriminated on multiple grounds and judgment must be viewed through multiple lenses, which is a very good point. She also added that it takes effort and time to do this, as well as knowledge, of course. So this is, we are repeating this all the time. And also Ivana said that Turkey went on the Istanbul Convention for the same reason that Bulgaria stated. Basically, in Turkey, issue is not so simple because the survey which was done in Turkey before they decided to withdraw from the Istanbul Convention showed that some, I'm not sure if I'm right, but around 85% of population didn't want to withdraw from Istanbul Convention. So we have some other political reasons why the state decided to do so. Mm-hmm. Okay, Lamia. Also, she had a question on the funding of feminist judgment projects, and also how are new judgments presented to the national judges. Okay, so Lamia, also there is sometimes those projects are not financed by others. These are really legal scholars who are enthusiastic about this work, so it's not paid. And now with these online possibilities, it gives them opportunity to meet online to discuss different issues, and it doesn't cost much. And there is always an interest for new projects emerging in order to have let's say monograph on this issue. So even some very famous publisher will be interested to publish monographs. And also we have some other possibilities if you're interested to initiate any project. But also some projects are are financed from some organizations, so you really need to go to dig and to see the possibilities for that. And for your second question, which concerns the presentation, it also we have different methods to that, but usually it is presented in a form of round table and also by distributing books in that legislation. Okay, folks, I see at least that those of you who are present, that you already read the case. So what do you think about this case? Do you think the feminist perspective was applied? And if not, what should be different in this case? Any thoughts? Larissa?
I think it was not applied at all. What I see here is the lack of intersectionality approach, so age and gender, which in the case, because it was 2 or 3 times stressed that the other employee, the new employee, is also mother, also woman, etc. Nevertheless, the woman who lost her position due to the maternity leave is a younger mother that faces much more challenges and pressures, and she is in full legal responsibility for her minors, while the other mother is not. So that is just only one part of the thing that I see.
Good. So you think that because the fact that she was replaced by another woman is not enough to find that we don't have a case of discrimination? Yeah. Okay, good. So what about others? Do we have also any other reaction to this case? Hannes?
Generally, there are lots of such similar cases about women, and I'm also a woman, but I think if I was a business owner, why should I hire women that they want to go few times for 1 year of maternity leave, and I don't know, they have some days low energy each month for working, you know? There are such cases happening a lot.
Okay, now you're opening another door, which was probably also the view of judges. It was not so included in the judgment, but that maybe some of them also relied on this thought, because this is a usual argument that you hear, why someone will go on several times to maternity and then parental leave. But we also have reaction in the group on that.
Yes, so basically here we see that she's really, she achieved really high position. So if you want to achieve high position, your question is, why do you want to be a mother? So that is my question. So we should decide if we want to be mothers of 1, 2, 3 children, or to pursue careers. Is that your question? I mean, is that your concern? Because you're completely depriving her of her, she's highly capable employee. That's stressed at the very beginning. And she lost her position only due to maternity leave, not due to her performance. You could let her at the beginning, give her 1 year of the performance in the new position, and then check how she performs in these new circumstances with 3 kids. Maybe you can do that, but give her opportunity and chance, because she reached that level in spite of deciding to be a mother of 3 children.
Okay, I'm not sure that Farnas wants to defend this this argument that she's raising that issue for the group. So Farnas, maybe you can defend yourself better.
I said because it's happening a lot. I mean, there are lots of similar cases.
I know, but it's discrimination cases, of course.
I understand, but I also understand the opposite part. I mean,
Yeah, that's the issue we're addressing here.
Yeah, actually, it's also my question. The same. It's also questioning for me.
The same question. Okay, so me. Okay. Yeah, it's good. I mean, it's good to be open and to discuss the case. So Mina, a labor law assistant, so she can help us here.
There are great expectations. Just like in relation to what was mentioned. Of course, that is often the employer's perspective, but the idea of creating labor law and anti-discrimination provisions in the labor law is precisely to put an end to such situations. So, in all fairness, employers often think that way, but exactly the idea of law in this regard is to put an end. What I see here as a challenge and a problematic thing is again the fact that laws tend to once again see everything through the perspective of one personal ground. So in this sense, we will protect women, but like if we have multiple grounds, again recalling just to this one ground, and I think that the step further needs taking into account multiple grounds at the same time and intersection. And just in relation to this case, I had to mention that to me, some paragraphs were very, very similar to one of the cases, which was actually the starting point for the foundation of the theory of intersectionality. So precisely this, she's not a woman. So just in this sense, it is often the employer's perspective, but like the whole idea of building a system of law in employment is to put an end, and the boundary where employers just, despite of their maybe interest, cannot go that far because it is discrimination and unequal treatment. So.
I mean, a good point. Before we go further, we also have a comment in the chat, but we don't see it because we have open presentation. So is there anyone who would like to take the floor, to take the mic? Tiana, please go ahead.
I just want to point that this is a very intention of the employer, in this case, to cover discrimination for lower salary by hiring the woman on this position while the first one is on maternity leave. Because you cannot really justify in this case lower salary, even if you're moving somebody to the lower position after maternity leave. It is much harder for the employer to let's say, to justify when you have the men on the higher position hired after the mother who is on maternity leave. In this case, this is a very, let's say, sneaky move of the employer. The employer hired a woman, put her in the position instead of a mother who is on maternity leave. And in this case, you can see how many employers doing this. I mean, let's say we have like gender equality. We hired a woman on this position, but the other one who is returning from maternity leave, she gets a lower salary.
Okay, Tiana, it's a good point. Some other reactions to the judgment. Do you think that? Sophia, please go ahead.
Yes, well, I had certain impressions while reading this judgment. That's a smile. Okay. So the reasoning didn't really ring with me in certain cases, especially the argument that this was not discrimination on the grounds of family status, because the family status is not the same. We have children as biological children and children as, legally speaking, children minors. So that's a difference in family status, which should have been emphasized in the judgment.
Okay, Sophia, in what respect? In what regard we see that this is different?
Well,
from the perspective of the employer, which led maybe to discrimination and which should be recognized by the courts.
It's a difference in the situation of the two employers and their capability to do the work. However, it's not my main concern with
this.
Okay,
can you just elaborate on this concept that you said that you cannot perform the same work? So what do you think by that?
Well, I mean that the employer thinks that in the future the woman who has kids who are minors is more oriented towards them and has a different work and family life balance than a woman whose children are 24 and 26 and maybe do not even live at the same home.
Now it rings the bell with me. So basically what we have here is the expectation on the part of the employer how much this woman will be involved in her work and not her performance. And this is why it needs to be acknowledged by judges. Very good. So now you can continue.
That's one part that didn't really ring true for me. The other question here is that if we imagine another situation where a male employee took 2 years off work for whatever reason and came back, would he be accepted at the same position if that position is one of those ever-changing where you have to be in touch with every step of the way? So is this really a case of maternity leave, or is this the case of the absence from work for 2 years, and what is the relation of these two facts? So this is a private company. It's a bank, but probably a private bank. And a private bank has a private economical interest. So if we judge this case, I'm not against the judgment, but if we judge this case as discrimination, it may have a counter effect of telling the employer, do not let women who are of childbearing age get to a high position, because then you will be sued for discrimination if you do not let them come back to that position after maternity leave. So maybe it is a question of certain public policy steps that should be taken. If it's a private company, there should be affirmative measures for the employer to get certain subventions or support to let that woman come back to that position, because this way we can't really expect a private business entrepreneur to just look, this is discrimination and I'm just going to disregard all my interests and go for the moral or good or right thing to do, because it's a beautiful idea, but it just won't work. So yeah,
it's not only the idea, but it's what it's enshrined in our constitution and legislation, and this is the answer to the fairness. No one should be guilty for using its legal right, which is recognized in the law. We can here discuss whether the policy of having 2 years of paternity leave for third child is good or bad, because usually we have, for example, in the EU, you know that maternity leave lasts for 3 months, and then women do not have more time to take parental leave, for example. So the policy on the length of parental leave is also on the part of the state. But if we have 1 year for first and second child and 2 years for a third child and any subsequent child, no one should be blamed for using it, relying on its legal right to use it. So what Sofia said, it's of course the issue of policy, but we cannot make such a distinction between public and private, because anyone who is working, who is having business in a certain state needs to obey with rules, needs to obey with the constitution and legislation, and in that regard legislation is very clear that we cannot have discrimination. Discrimination is prohibited. The consequence of what Sofia said could be this, but then we have other measures how to combat it. And for example, in our law, new law, which was adopted in 2021, we also have some assessments that need to be done by either private or public companies. And also we need to have gender equality plans, which need to be adopted and then sent to the Ministry, for example, for Human Rights, which supervise what was done. So that would be one of the measures how to combat that consequence that Sofia just said. So we need to, another way, we need to find other ways to support non-discrimination in one country. But what we cannot allow is that the judge does not recognize this issue and that does not apply laws which need to apply in that case. So why this case is interesting? I know that we also have some comments in the chat, and some of you said that this is not a case of discrimination. So I think, and this is why we gave you one case where also judges even relied on the explanation that the bank has, and this is that the running the business, it's important to put this woman in a lower paid position. The only thing which was relevant for bank was that the qualification for each jobs was the same, but you've seen that economically the consequence of having one or a second position was totally different. So what we are doing in this case, a woman who has a third child and she is returning from parental leave, she is capable, and this is what Larissa raised, because for some time she was working as a head of one branch in this bank, so she was very successful in that. So what we are doing, we are putting her in a lower position at the time when she needs money, because also what Sofia said, she is not in comparable situation with another woman who replaced her. But of course, it's not the main argument. This is just a consequence of this action and decision of the court. But basically, what we need to do as lawyers, as judges in this case, the first thing that we need to see is what's the rationale for the bank. What's the legitimate aim on the part of the bank to replace her, to put her in a lower paid position? And here we have explanation where the bank said, being a head of branch, you really need to know the clients. But we will replace this woman who was 2 years away from the job, and she doesn't know what are the news streams and what's happening in a banking sector at the moment. So she will be a counselor you know that in each bank you have counselor for certain clients. But what do you think? For which position you need to know clients better? How you will consult clients if you're not aware of what's going on in a banking system at the moment? So the first thing that those judges were blind to find is that here, although the bank didn't say, oh, we replace her because she has a third child and she will not be capable of having a head position, was basically that she will, as Sofia raised that issue, she will not be capable because she will be concentrated on home and on her kids, so she will not provide and perform the job adequately. So they didn't give her a possibility to show that it's not true. They replaced her almost immediately, and then the bank gave us a wrong explanation of why they did so. However, it's really hard, as we have a neutral practice here, to find discrimination. So what we need to find in this case? We need to find basically what the bank is doing in this area. Do we have one unique case, or we have more cases which are similar to this one? And here, this is why what Marija Vlajković was talking about two days ago, why here we have reverse burden of proof. What information we can seek from the employer? What we can seek is how many women in some previous period of time, let's say 2-3 years, went to maternity or parental leave, how many of them returned to the bank, and how many of them in percentage were replaced to a lower paid position. And here, if we have a statistic which is standable, what we will find? We will find a case of indirect discrimination. This information are missing in your case because this is what Commissioner for the Protection of Equality stood up. So this was the case of strategic litigation. So it means that it was recognized as a very important case for Serbia, as Padna said, because we have widespread discrimination in the employment and very similar as this one. So the Commissioner asked the bank to provide this information, and we got that something 40% of women were replaced, but those who were in higher position. So here we have basically more than all this information which are in front of us. So what's so problematic with this case? First of all, it showed that judges still do not understand how to prove the case of indirect discrimination, because no one on any level, any instance, did not deal with these statistics. For them, it was the only issue which was important was this comparison between two women, and they did not find discrimination. Then again, the question of reverse burden of proof, because in this case we had Commissioner who asked for those information, but in majority of other cases, if we have a victim who initiates the procedure by himself or herself, she will not know how to what to ask and what other sides should provide. Another problem is this legitimate aim. It's really a great, let's say, challenge for our judges. You give them any legitimate aim, which seems like to be an illegitimate aim, and then we say, oh, okay, it's good, we have legitimate aim. But legitimate aim needs to be linked with the practice. So what we are doing and why we are doing so, which was obviously not present in this case. Then, of course, sources that need to be invoked. Here we didn't have any single reliance on international law and international standards. We didn't have also any reasoning in the decision of the court that discrimination in the employment is widespread, what are the consequences, how many family issue matters, and we already mentioned the issue of intersectionality, which is another issue, and this family status was really not explained by any judges. What we can conclude here? We conclude that if we have a new judgment rewritten, we can show a totally new perspective to our judges. So how they should approach this case. And of course, to show not only international, but also domestic sources which were not taken into account in deciding this case. Then again, we can show to judges how certain institutes which are stipulated in the law should be interpreted, such as indirect discrimination, reverse burden of proof, and such. Then we can show to judges how, taking into account all these elements, we will come to another conclusion, and conclusion would be that this is a case of discrimination. Then another one that I wanted, this is the final one that I wanted to show you, and I will leave you with that. Our argument on having certain number of women in the benches is important. But look at this. In this case, we, at a first instance level, we had only one judge. And the single judge was female. So she first did not recognize that this is a case of discrimination. On a second level instance, we have in the bench 3 female judges. Again, they did not recognize that this is a case of discrimination. And then finally, we have a Supreme Court of Cassation when we had 3 judges again, 2 female and 1 male judge, and the decision was again the same. So having female judges in the bench does not mean that we will have better court practice. It just means what we repeat and repeat is that awareness raising, trainings, continuous trainings, combating stereotypes and prejudices is necessary in this field to make a difference. And with that, I will conclude this session. And before you go for a long-deserved break, I'll give the floor to Professor Dragica Vujadinović.
So Ivana finished this excellent presentation together with Bojana with implied and explicitly articulated ideas about the importance of gender sensitization and gender awareness raising and gender competent approach of judges and overcoming their biases and stereotype basis of their decision making. And I also mentioned during my presentation this morning about the importance of gender awareness raising, about gender mainstreaming, gender sensitive and gender competent knowledge as the mission of this spring school and one of the main focuses. And as a matter of fact, what I want to finish with is that in this line of the attempts towards gender mainstreaming within legal education and higher education, I just want to mention that within our project of building the Master Study Program Law and Gender, LOGEM, we published the book Springer, as a matter of fact, published the book, the textbook Gender Competent Legal Education, which we uploaded at your Moodle because we had the right to do that because of the open access character of that book. And that book contains, as you could see, a huge number of chapters, 17 chapters, which attempt to cover all fields of legal education and multidisciplinary fields relevant for legal education in particular chapters from the gender perspective or gender lens. Also, Professor Ivana Krstić and I initiated something what at the beginning did not intend to be the book series, but due to the quality of received contributions, a huge number of them based on the call for gender approach to different legal issues. Springer offered us an opportunity to establish the book series, which I want to. So, Ivana, you can help me because
sure.
Those who are online, I think it deserves to be shown. So we established together with Springer the book series Gender Perspectives in Law, and already have published 4 books: Feminist Approaches to Law, then that's the theoretical, then the Gender Perspectives in Private Law, Gender Perspectives in international and European law, and gender perspectives in public law. That's, how to say, the beginning of this, I think, very useful and successful undertaking, and the forthcoming books in 1 year, let's say so, again, within this book series will be, just to mention the titles, Gender and the Judiciary, then the 6th book, Reassessing Feminist Legal Theories, then in a little bit later period of this book series, new volumes, we will get one related to gender perspective in medical law, and one on reconsidering feminist theory and practice, etc., etc. So we are, I think, on a good track in this attempt related to gender mainstreaming of higher education, and especially legal education.
And with that, we announce a break until 5 p.m.
And if you allow me, so there are some problems, demonstrations, and whatever gatherings, etc. So I do not want to comment it now. But the situation is that I have to ask you: will you stay? And because at 5 o'clock we will start with the gender equality in business law. And just to remind you that tomorrow morning we will have holding the course related to tax law and gender perspective in tax law. So for today, professors are coming on foot. They will be here in the conference room, and I hope that some of you or all of you will stay and listen to them. And then, of course, we will have online participants who opted also for this interesting and relevant course. So I hope that some of you or all of you will stay and listen to the presentations and take part in the discussion.
So for example, it was not in my.
Yes,
I'm
yes.
just asking. It was not my optional course, but I will attend online, because I think there's going to be something today, Bojana, or
Really?
Yeah.
Really?
after 3.
Okay.
That's why I have to, because otherwise I should go by 1 to a student's class.
So you can also stay here in the conference room and or come back at 5 o'clock when the course will start. Okay, thank you.